This is Michael Popok, Legal AF. It's a hot take on a stormy day, and it's all about Donald Trump and a law that was amended in New York to address Donald Trump's frequent use of vexatious, meritless litigation and how it was used against Donald Trump, and now he's required to pay almost $500,000 to the New York Times because he and his brain trust, heavy lift there in the term brain trust, of Alina Haba, decided to not only sue Mary Trump, his niece, a few years ago off of a New York Times Pulitzer Prize winning report about how Donald Trump's father used tax dodges during the 1990s, and that's how Donald Trump inherited almost $500 million to start his career. That Pulitzer Prize winning article was based on information that Mary Trump had obtained in her fight over the estate of Fred Trump, Donald Trump's father, and Mary Trump, Donald Trump's mother, and she received 40,000 pages of tax returns and tax information about Donald Trump. The New York Times obtained a copy of it and protected, as Judge Reed of the New York State Court, a Supreme Court Commercial Division where I practice regularly, ruled it was totally appropriate for the New York Times, under First Amendment, under concepts of prior restraint, under the New York Constitution, to have obtained that information the way that they did and published that information in the article, Trump Engaged in Tax Fraud and Reaped Financial Rewards with Father, which ran in October of 2018. The judge, Judge Reed, dismissed the New York Times back in May of 2023 under an amended version of New York's AntiSlap Statute. So now we'll do a little Legal AF breakout session. SLAP, almost every state has it, it's meant to address the vexatious use of litigation to try to chill people's First Amendment rights. It stands for strategic lawsuits against public participation. It's when you bring a suit, not because it has any merit, but because you want to try to intimidate and silence somebody's public participation, in this case under the First Amendment, and who has a bigger, broader right, more robust right to First Amendment protection than reporters. Well-established line of United States Supreme Court precedent dating back to our founding fathers protects reporters, such as those for the New York Times, who obtain information, no matter what the source, confidentially, and then run to publish it. Judge Reed had effectively two motions to dismiss that were pending back in May, one by Mary Trump, which he denied. That case is still pending. The argument that she breached her confidentiality restrictions from 20 years ago by providing the information. But the issue of the New York Times is a different one. And this is the mistake, again, that Alina Haba made in guiding her client into filing the suit. Now, look, this SLAP statute, anti-SLAP statute, was actually amended but in order to address Donald Trump. I'm not saying that he was the only reason they amended it, but they tightened the screws of that and allowed for attorney's fees to be awarded. And that was on the books before Alina Haba signed the pleading for Donald Trump, meaning she knew or should have known about the New York law that would have subjected her client almost immediately to $500,000 in attorney's fees. But again, fell asleep at the switch, didn't care. I'm going to give you a long list of things that Alina Haba has done wrong. I mean, she's busy doing all sorts of things to her appearance and wearing all sorts of designer sunglasses and making sure her outfit is just so perfect when she's standing next to Donald Trump, at a MMA fight or in the back of a courtroom. But how about learning, I know she's a New Jersey lawyer, but how about learning the basics of New York law under the CPLR, which is our governing Bible for civil procedure, or under New York statutes? I'm a practicing lawyer in New York. I've been so for 32 years. I keep up to date with continuing legal education in order to improve my practice and to sharpen my skills. Try that, Alina Haba. How about not walking your client into a minefield of a statute that was amended to address your client and then have you file it and then get awarded the exact damages that the statute was meant to address? So let me tell you specifically what happened here. In 2018, The New York Times, based on the information provided by Mary Trump, published an article October 2nd, 2018. You can find it online with the New York Times, called "Trump Engaged in Suspect Tax Schemes as He Reaped Riches from His Father." And the premise is that through a series of tax dodges led by primarily his father, Fred Trump, Donald Trump ended up benefiting to the tune of $453 million in 1990 dollars. It's a nice way to start off a $500 million transfer of wealth that avoided taxes. Sort of undermines the argument that he's a self-made man and he's a billionaire by his own right. Sure, he took $500 million, which is now worth several $billion in today's dollars, from his father through tax dodges, as reported in the New York Times. They won a Pulitzer Prize for that, for one of the best investigative reportings of that particular year. But that didn't stop Donald Trump from going after and arguing that the reporters were in an insidious plot, that's a word from Donald Trump, with Mary Trump, his niece, to bring him low. That's the argument. But right away, the New York Times, smartly, with very good First Amendment lawyers, I've met a few of them in my day, and their general counsel, decided to go after Donald Trump and try to use the AntiSlap Statute exactly as it was written, exactly for this purpose, as Judge Reed has noted, which is to early in the case get a slap, an improper slap case, a strategic lawsuit against public participation, dismissed early, and then under the statute as amended, award attorney's fees. That's the miss by Alina Haba. If you look at the actual slap statute, it says that in order for them, the New York Times, to prevail, they had to show that there was the cause of action, pardon me. In order to avoid, the slap statute, the Trump had to show that the cause of action had a substantial basis in law, it was supported by substantial argument for the extension or modification or reversal of existing law. But the new standard applies to actions such as this. Prior to 2020 and the time that Donald Trump filed the suit, actions involving these kind of public petitions and participation were limited to instances where speech was aimed towards a public applicant or permittee. It was a governmental thing. But in 2020, New York State expanded the scope of those actions to include any communications in a place open to the public or public forum in connections with issues of public interest. Meaning now it went from, I'm trying to get a permit down at City Hall, to anyone who's commenting in the public forum and the public square in connection with a public interest. That means newspapers. New York Times then became a proper petitioner or plaintiff to countersue under the anti-SLAPP statute, a fact that Alina Haba should have known before she let her client file this suit, but she ignored it. In fact, the judge commented in awarding the attorney's fees to the New York Times to almost $500,000 that the revised, quote, anti-SLAPP law was specifically designed to apply to lawsuits like this one. In fact, among other reasons, plaintiffs' Trump's history of litigation that some observers, the judge continued, have described as abusive and frivolous, inspired the very law that I'm now awarding damages and attorney's fees under. And when you have a law that's effectively written with your name on it, you maybe shouldn't file a lawsuit that violates that law right on the heels of it. Now, either Alina Haba now here's my theory. She missed it. It was an amendment. 2020, COVID was going on. She was very busy doing whatever she was doing with Donald Trump, shopping online and representing him in ridiculous cases. And so she missed it. Or she advised Donald Trump not to do it, and he said, full steam ahead, I want to go after my niece and the New York Times. That's theory number two. I think we're closer to theory number one, that Alina Haba missed it, because she's missed a lot of things, and we've covered them here on the MeidasTouch network. She missed, for instance, that apparently Donald Trump, she forgot, was president when he defamed E. Jean Carroll, as has been determined by a federal judge. We have a trial starting next week because she failed to raise, I don't think she would have won, but she failed to even raise whether Donald Trump, as president at the time he made those defamatory statements about E. Jean Carroll, claiming that he not only didn't rape her, as a jury has already determined, but he didn't even know her. All of that happened while he was president, you'd think that you'd somewhere in your pleadings, your filings with the court, your arguments, somewhere in 3 years, you'd raise presidential immunity if you thought you had it. Now, I don't think they have it, because under recent decision-making at the D.C. Court of Appeals level, including a case called Blassingame, I doubt that Donald Trump will be found that this defaming a woman victim who claims that she was raped and sexually assaulted by Donald Trump and then defamed by him falls within the scope of even the outer perimeter of his most stretched presidential duties under that line of cases. But you need to raise the issue. And the Second Circuit Court of Appeals roasted Alina Haba on her feet at the oral argument when she tried to argue that, well, she may have waived it, but you can't waive it. It's unwaivable. And they denied his appeal and found that she had waived effectively any kind of argument of presidential immunity because she waited 3 years to raise it. And Donald Trump, as of right now, has not. I don't think he's going to bring an appeal, an emergency appeal to the United States Supreme Court, and that case is starting this coming week. Now, his mother-in-law died, and he tried to get out from the trial for a week, but not because they're trying to file papers, I don't think, at the U.S. Supreme Court level. That's an Alina Haba screw-up. Another Alina Haba screw-up is why the trial of the New York civil fraud case that just concluded is a bench trial and not a jury trial. Sure, under the way the statute is written, the one that the New York Attorney General is going to ultimately get $400 million on behalf of the people of the state of New York against Donald Trump, the way that's written, on its face, it should be a bench trial, not a jury trial, meaning a judge should decide, not a jury. But there is an argument to be made that the jury could have had a role in the case, but you needed to make that argument to the judge, Judge Engoron, and then ultimately take it up on appeal. And Alina Haba fell asleep at the switch there and did not raise that issue either. But we're not done. Alina Haba was also the lead lawyer in the E. Jean Carroll case. I think she's going to be the lead lawyer coming up this week in the E. Jean Carroll case again. And when she had the case, she didn't try it because she screwed up so many times even Donald Trump had had enough. And he sidelined her and let Joe Tacopina take the case the last 90 days, and he screwed up terribly, and Donald Trump lost the E. Jean Carroll case. But Alina Haba's back, apparently in Donald Trump's good graces. They've, as my co-anchor Karen Friedman-Agnifilo recently said, they broke up, but they got back together again. And she screwed up the first trial so badly that, of course, it put Donald Trump into a hole even before he walked into the courtroom. She screwed up evidence. She screwed up trying to get any kind of DNA testing of the clothing that the victim wore on the day of the attack that she said that she had, because she made such a mess out of it. In terms of never having asked for the DNA to be tested, it was denied. She screwed up other discovery. She got her experts stricken that she was going to use to support Donald Trump. That's how bad Alina Haba was. Screw up after screw up after screw up in the trial level, which ultimately contributed, I believe, to the loss by Donald Trump in front of that jury. And now you have yet another example, letting your client file a suit in almost automatic, on its face violation of a statute that was amended to address your client. And now Donald Trump is going to have to pay $500,000. Now, if he doesn't like the result by Judge Reed in the New York State Supreme Court, which is the trial level court in New York, he's got two options. He can take it up to the First Department Court of Appeals, or the First Department of the Appellate Division of New York, which is the intermediary appellate court that sits over the trial level. That's commonplace. I've done that. I'm a member of the First Department myself. If you lose there, you can take it up to the Court of Appeals, the highest court in New York. And that's it. There's no federal, you're not jumping over to the federal side and having the federal courts get involved. All this happened, had nothing to do with Donald Trump as president. But that's the lesson. If you're gone, you got to dance with the girl you brought. And Donald Trump is dancing with Alina Haba, despite the fact that she's screwing up time and time again and leading to substantially a lot of attorney's fees being paid. I mean, the E. Jean Carroll judgment, which is on appeal, required Donald Trump to post a $5.5 million cash bond, which is sitting with the clerk of the court, ready to be paid over to Alina Haba when that appeal ultimately fails, and I believe it has, and so she's going to get that $5.5 million. Here's another $500,000 over to the New York Times. Donald Trump and Alina Haba got fined $1 million down in Florida, the Southern District of Florida, for having filed a meritless, vexatious suit against Hillary Clinton, the Democratic National Committee, Debbie Wasserman Schultz, and everybody else related to some sort of conspiracy to bring down Donald Trump. That got dismissed without merit, bad faith, and $1 million fined against Alina Haba and Donald Trump. Suits that they also involved with trying to sue the Pulitzer Prize board, the Nobel Prize board, and all of these other things just to get attention. This is just, again, Donald Trump, another million here, another $500,000 there, grifting off the back of these cases to raise money and separate his and dupe his followers and separate them from their money. This is what we're watching. We're calling it out here, one place, the MeidasTouch Network on this YouTube channel. And I do hot takes like this about every day at the intersection of law, politics, and justice. We wrap it all together in a podcast we call Legal AF, and the title is exactly what you think. It's every Wednesday and Saturday at 8 p.m. Eastern Time. Help MeidasTouch Network get to 2 million free subscribers. They're so close, 70,000 short, 50,000 short, something like that. And until my next hot take, leave me a comment here, give me a thumbs up. Keeps the network and me on the air, keeps the lights on. Until my next Legal AF, this is Michael Popok reporting.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.